Good morning, everyone, and welcome to Juris Root with us today. We have Namrata and Itisha. Today's topic is Res Ipsa Loquitur. It is given under Law of Torts, and it comes from a Latin phrase that is the thing speaks for itself. Okay, the thing speaks for itself. It means the thing is so obvious, prima facie, on its face, that there is no further proof required for the plaintiff to give to the court. Okay, so what are the essential ingredients for this doctrine? The first one is the plaintiff did not contribute to the cause. Okay, there should be no fault on behalf of the plaintiff, and the plaintiff should not have contributed to the cause. Okay. So this is slightly a part of negligence. Like we understand and read contributory negligence, where plaintiff has certain role and part to play in the negligence caused. So under this doctrine, the plaintiff should not have contributed to the negligence or the accident that has occurred. The second important essential ingredient is the accident was of such a nature that it does not happen without negligence. Okay. And the third one is the accident was caused by something that was completely under the control of the defendant. The defendant was in control of that particular thing or accident due to which that negligence happened. The fourth one is the doctrine, that is res ipsa loquitur. It shifts the burden of proof on the defendant because it is presumed that defendant was negligent. So here plaintiff has to only say and put in front of the court that he was a victim of the accident, and then the burden completely shifts on the defendant to prove that defendant was not negligent and it was not his fault due to which the accident happened. This can be simplified with the help of an case law, and that is, this is one of the famous case law, Bryan versus Bodel. Okay, in the year 1863, and after this case, this doctrine came into picture more evidently. Okay, the facts of the case were as such: a barrel of flour fell from a warehouse and it hit the plaintiff while the plaintiff was walking on the road. Okay, so it was held that a barrel does not fall by itself, right? It must have fallen due to someone's negligence. When defendant pleaded that it was not his fault how the barrel rolled and fell upon the plaintiff. Okay, so the court said that a barrel cannot come by itself, roll and fall on the plaintiff, right? It has to be someone's negligence. So the barrel of flour that was there in the shop of the defendant, it was the defendant's responsibility to keep it, in a guarded manner, in a protective manner, so that it does not occur, does not cause any kind of accident or does not harm anybody. So the defendant was exclusively under the control of the barrel. Okay. This accident happened due to the defendant's negligence. Thus, in this case, res ipsa loquitur was applied. Similarly, in another case, Scott versus London and Saint Catherine Docks and Co. Okay, in the year 1865, England, the facts of the case was that the plaintiff was injured by a bag of sugar falling from the defendant's dock. So now we generally don't keep bag of sugar, unattended. So there must have been certain negligence on the part of the defendant that a bag of sugar wasn't kept properly on the dock, due to which it fell on the plaintiff. Okay, the plaintiff was injured due to that. And when the defendant pleaded that no, I should not be held liable because it was not under my control, that plea was discarded. The court said that the bags do not fall without negligence on its own. So this thing, it speaks for itself. How the bag fell on the plaintiff and who should be responsible, it is completely evident in the picture itself. We do not need any more proof. So thereafter, under this case also, res ipsa loquitur was applied, and the essentials that we read in the previous slide, all those ingredients were put under this case. Now coming to the cases from India, Namrata ma'am will be explaining it further.
Thank you, Itisha ma'am. So in India, there are two important cases that we'll be dealing with. The first is Sham Sundar versus State of Rajasthan. It is a 1974 case. What happened in this case was that the workers died in a truck accident due to brake failure. Now the brake failed and the workers died. Now whose fault is it? The brake failed, so they died. So that was a defense that was taken, but it was held that the maintenance was the duty of state employer. So therefore the principle of res ipsa loquitur was applied and they were held guilty for the same, because even though the brakes failed, but the maintenance should have been maintained, and if that would have done, the brakes would not have failed. So that was the
Hmm.
case of res ipsa loquitur, the Sham Sundar case. And the second case is Municipal Cooperation of Delhi versus Subhagwanti, another very famous case of 1996. Yes. So the clock tower collapsed and killed people. So there was a clock tower, it collapsed and many people were killed. So here it was held that the structure was under MCD's exclusive control. So the municipal corporation's control was there on the maintenance of the clock tower. So they did not maintain it well enough, therefore it fell. So it was held that negligence was presumed through which principle? Through res ipsa loquitur. So here the falling of the clock tower spoke for itself that I am not maintained, therefore I am falling. So this was held in the case of Subhagwanti. Okay. Uh,
Right, right.
Itisha.
Yes. So I hope we have, enlightened you on this topic. Thank you so much for watching us.
Thank you.